This is the issue, and I am the ghetto man. Today's show is going to be the third show dealing with your right to self representation and counsel of choice, dealing with the Sixth Amendment. Now, there are other aspects of the Sixth Amendment, but right now we're just covering the area dealing with your right to self representation and then your right to counsel of choice. Anyway, what I'm going to do is I'm going to actually read directly from a, a, a brief. Anyway, what we normally do is when you're in court, for those of you that don't know how it works, is that when you want the court to do something for you, you have to ask it. And to do that, you have to do what they call a motion. And a motion puts the court in motion. And basically, what a motion is just asking the court for something. You know, like I say, I'll give you a really simple example. You know, a motion is asking the court, let's say, for a drink of water. Okay, then with that motion, it comes a brief that supports the motion, and the brief that supports the motion is nothing more than giving the court a reason why that you should have a drink of water. Now, in this case, this particular brief is a little bit different than a regular motion, but it is a demand. Sometimes you have to place the courts on what we call judicial notice. You want to make sure that the court understands that you're going to be coming into that court and you're going to be exercising a constitutionally protected right. You want the court to recognize that right, and that you're not going to put up with the court saying, well, no, we're not going to give you that right. What it is it's your position and the reason why you're going to do something in court. So if this one here is basically a judicial notice is what the brief is, in support of demand for self-representation and counsel of choice. Now, this particular brief, I've used this many, many times over the years. And it's pretty interesting because even though it's completely legally correct and it outlines my constitutionally protected inalienable right to represent myself in court and to conduct the proceedings in my own way, in my own manner, providing I'm not disrupting the decorum of the court or violating any court rules. I've given this brief, and not one time has a judge been able to first refute it, and two, ever grant it. But the results have been kind of interesting because on two different occasions, the first one, a judge said he'd take this into consideration and he'd let me give me his ruling. He never ruled on it, and then when he left the bench, was voted out of office, he just dismissed the case and didn't even let me know about it. I didn't find out about it for years later. But what they do is what they call sandbagging. If they don't want to address a certain issue, they just don't do anything. And they just kind of leave everything hanging because this is such a controversial issue. In fact, this is going to be the first time that I've ever taken this brief and just made it totally public. I used to teach it to some of my students privately in a school that I used to run to teach people how to use the courts without a lawyer. Anyway, this brief will be the first time I've addressed it given it directly to the public, and I want the public to have it. In fact, I've made up a PDF file that will be in the description part of this video. Now, all I'm going to do today is very simple. I'm going to read through this, and I'll make comments from time to time, and I'm also, I think that the argument as it's presented to the court, everything that I've taught you up to this point, you're going to be able to, it's all going to come together and you're going to see the big picture here. I had one time, I took it up on appeal here in Montana on this issue. One thing I want to say this very quickly. One thing that's always happened to me when I've done this is that the courts will never address this argument. They will literally, every single time, they will come up with an argument. They'll create their own argument, and then they'll go ahead and address that, because this is so important. And it also demonstrates to everybody that's been following my shows to this point how corrupt the judicial system of government is. Now, if we're going to turn this thing around, we really, like I said, you really have to educate yourself and understand how the Constitution works. And we're going to have to go into areas where most people don't want to go, and that's getting into the actual argument on a constitutional issue in court. As I was saying, the courts will. It's funny, even though this is well-settled law, and when I say well-settled law, it would be what the lawyers would call case law or benchmark decisions. These decisions are so important that, every court that's out there, should follow this. And that's what the United States Supreme Court is saying. It should follow this because this is such a fundamental right and it's very important. So anyway, I'm going to go ahead and start. We're just going to go ahead and start to read the brief from its very beginning. And like I said, we'll just go ahead and discuss various different aspects of it as we move along here. All right, so let me move this in position where I can see what I've got here. Okay, starting with the first paragraph on page 1. And I removed my name from here so that, if a person wants to go ahead and insert their own here. But I really strongly suggest that if you use this argument that you really understand it. And I mean understand it to the point that you could sit down and discuss it with me and we wouldn't have to open this brief, okay? Anyway, I think you're going to find this very interesting. I don't think it's boring reading. I think it's going to open your eyes to exactly how important your right to represent yourself is, and as you're representing yourself, maintain your right to counsel, assistance of counsel of your choice. Okay, the accused defendant asks the court to take judicial notice of his right to self-representation as set forth in the Supreme Court decision of Feretta versus California. That's found in 422 U.S. 806, and his right to counsel of choice pursuant to the Sixth Amendment of the United States Constitution and Article 2, Section 24 of the Montana Constitution. Further, accused defendant asks the court to take judicial notice of Public Law 97-280, 97th Congress, October 4th, 1982, 96 Stats 1211, proclaiming 1983, the year of the Bible, and the Holy Bible, the Word of God. First argument, accused defendant has a sincere distrust for all members of the state bar. Accused defendant has a sincerely held religious belief that all lawyers, including judges because they too were lawyers, are bent on convicting citizens who desire to appear in propria persona and exercise their constitutional rights. For over 14 years, it's been more than that now, but 14 years, I think this was written back in 1999. For over 14 years, accused defendant has been victimized by local government prosecutors. These prosecutors are no longer concerned about justice. They twist the law, destroying all of our traditional values, and then use it to secure convictions against innocent, law-abiding citizens. Now, I'm going to go ahead and quote from a footnote from the case of Feretta versus California. And some of you have heard this before if you listened to the two shows before this, but it's in the brief, and it's all part of laying out exactly what your constitutionally protected inalienable rights are. When the colonies were first settled, the lawyer was synonymous with the cringing attorney general and the solicitors general of the crown and the arbitrary justices of the king court, all bent on the conviction of those who opposed the king's prerequisites, and twisting the law to secure convictions. This prejudice gained strength in the colonies where distrust of lawyers became an institution. Sound familiar? Several colonies prohibited pleading for hire in the 17th century. So it's saying here that several of the colonies would not allow anybody to plead for hire, a lawyer, a barrister, a solicitor. It was outlawed. Lawyers were outlawed. The prejudice persisted into the 18th century as the lower classes became to identify lawyers with the upper class. And once again, what's different than today? The years of the Revolution and Confederation saw an upsurge of anti-lawyer sentiment, a sudden revival after the war of the Revolution of the old dislike and distrust of lawyers as a class. Now, you've heard people over and over again today say, oh, a lawyer, man, he just took me for everything I got. By the time I got done, I won the case, but he owns all my stuff now. And there's a reason for that happening. We talked about that before, and that's because the legal profession has a monopoly over the judicial branch of government. In the heat of these sentiments, the Constitution was forged. That can be found in Freda versus California at 826 and 827. Accused defendant shares the same virtues of self-reliance and the traditional distrust of lawyers that the colonist did and does not desire an unwanted lawyer counseling in him in his defense. Argument 2. Accused defendant has a sincerely held religious belief that precludes him from taking counsel with a licensed lawyer. Now, based upon accused defendant's sincerely held religious beliefs, training, and understanding, he is precluded from using the services of a lawyer. Accused defendant's religious beliefs are a direct result of his applying Public Law 97-280, 97th Congress, October 4th, 1982, proclaiming 1983 as the year of the Bible to his life and the lives of his family. Now we're going to read Public Law 97-280, joint resolution. Whereas the Bible, the Word of God, has made a unique contribution in shaping the United States as a distinctive and blessed nation and people, whereas deeply held religious convictions springing from the Holy Bible or the Holy Scriptures led to the early settlement of our nation, whereas biblical teachings inspired concepts of civil government that are contained in our Declaration of Independence and the Constitution of the United States, whereas many of our great national leaders, among them Presidents Washington, Jackson, Lincoln, and Wilson, paid tribute to the surpassing influence of the Bible in their country's development. As the words of President Jackson, the Bible is the rock on which our republic rests. I just wanted to bring up there. Notice he said republic and not democracy. And we have a video on democracy, and I suggest if you haven't watched it to take a look at it. It's pretty interesting and should open your eyes about what form of government we have here in the United States. Whereas the history of the nation clearly illustrates the value of voluntarily applying the teachings of the Scriptures in the lives of individuals, families, and societies. Whereas this nation now faces great challenges that will test the nation as it's never been tested before. And whereas that renewing our knowledge whereas that renewing our knowledge of and faith in God through Holy Scripture can strengthen us as a nation and a people. Now, therefore, be it resolved in the Senate and the House of Representatives of the United States of America, Congress assembled, that the President is authorized and requested to designate 1983 a national year of the Bible in recognition of both the formative influence of the Bible has been for our nation and our national need to study and apply the teachings of the Holy Bible and Scriptures. Accused defendant has read the Bible and recognizes the great influence it has on our nation and the importance of obeying God's law above the laws of man. The Bible has taught accused defendant that lawyers are hypocrites and have always taken away the key of knowledge. And then quoting directly from the Bible, but the Pharisees and the lawyers rejected the counsel of God against themselves. You can find that in Luke 8:30. Woe to you also, you lawyers, for you laden men with burdens grievous to be borne, and ye yourself not touch the burdens with one of your fingers. Luke 11:46. Woe be unto you, lawyers, for you have taken away the key of knowledge. You enter not yourself, and then that we're entering in ye hindered. Luke 11:52. Having been enlightened by the word of God, the accused defendant must only take counsel with his fellow believers. See United States versus Seeger, 380 U.S. 163. Now, argument 3. Accused defendant has a constitutional right to conduct his own defense in his own way and his own manner. In a state criminal trial, accused defendant has a constitutional right to proceed without the representation of a licensed attorney when he chooses to conduct his own defense. Freda versus California again. Recognized that Freda versus California recognized that the right of self-representation in federal courts has been protected by statute since the beginning of our nation. And then we're going to quote from the Freda versus California case again. In all courts of the United States, the parties may plead and manage their own causes personally or by the assistance of counsel. Freda, and that's be found at page 813 if you got a copy of that. You can get that copy of that on the internet. Just type in the case citing and it'll come up. Okay, the question before the Freda court was whether a state may constitutionally hail a person into its criminal courts and there force a lawyer upon him even when he insists that he wants to conduct his own defense. The court concluded that a state may not constitutionally do so. Likewise, accused defendant does not want any member of the bar forced upon him, nor does accused defendant waive his right to counsel. See, what the courts are going to do is when they say you represent yourself, that you waive your right to counsel. Well, that's bullshit, okay? You can represent yourself and still have the assistance of counsel if you choose. And you can take counsel with anybody you choose to take counsel with. Okay, now, it's important to note, and this is in the brief, it's important to note that Freda makes no new law with respect to a person's right to assistance of counsel when proceeding in propria persona. As we talked before, that means in your proper person. The courts today now use the term pro se. Pro se one is that's representing himself. But in propria persona is used when someone's appearing as a proper in their proper person, which is generally used as a challenge to jurisdiction. Okay, and in order to clarify the right to assistance of counsel and the right to dispense with a lawyer's help, the Freda court explored the historical development around this subject matter. For example, the 1776 Pennsylvania, oh boy, I can't even say that. The 1776 Pennsylvania Declaration of Rights said, either party has a natural right to plead his own cause. This right is consistent with safety. Therefore, it is retained. But the parties may not be able, therefore, the civil right of pleading by proxy, that is by counsel, is an appendage. We all know what appendage is, something that is attached to. It's like your appendix, appendage. Is an appendage to the natural right of self-representation. And that's Thomas Paine on the Bill of Rights. So it's very important when you take a look at this thing, they're telling you, yes, you have a right to represent yourself, but you do not have to surrender your right to counsel because you are representing yourself. Okay, you see the citation there in the brief, those of you that have downloaded it. Anyway, going on, it says there is no evidence that the colonists and the framers ever doubted the right of self-representation or imagine that this right may be considered inferior to the right of assistance of counsel. And then notice that word, I keep hearing it again, assistance of counsel, not the representation of a lawyer. Assistance is different than representation. And that's something the courts will never address, because if they have to address that, then they would have to see that this argument is valid. But since they have a monopoly on the courts and they don't want you coming in there, and they sure as hell don't want you to have anybody sitting at counsel table with you that's going to help you. They're not going to do that. In fact, it's something that's been done so many times to me, it's just laughable. Okay, when you go into court, the courts say, okay, if you're going to represent yourself, you've got to be all alone. You can't have any assistance. It's nuts. Well, anyway, back here, going back to the brief there. To the contrary, the colonists and the framers, as well as their English ancestors, always conceived the right to counsel to be used at his option in defending himself. That's Freda versus California again. That's at page 832. Going on, it says, but it's one thing to hold that every defendant, rich or poor, has a right to the assistance of counsel. Once again, you notice the word assistance. You'll find that in the Sixth Amendment, and you'll find that completely through all of the court's rulings. When these courts made these rulings, they understand what assistance is, and they understand what representation is. Although they will never address the issue of assistance, even though that's the wording of the Sixth Amendment. We know the Constitution is the supreme law of the land, and for any law to be valid, it has to be an agreement. Rich or poor has the right to assistance of counsel, and quite another thing to say that the state may compel the defendant to accept a lawyer he does not want. So, this is something that's very important here, and I just want to stop for a moment. All lawyers are counselors, but not all counselors are lawyers. Does that make sense? Well, anyway, moving on. We'll take a look at that as we move along here. Okay, that was once again Freda versus California, and as it says in the brief at 833. After taking exhaustive historical note on the issues of the right of self-representation and the right of representation by an attorney, the court went on to recognize the inalienable right of one to plead and manage his own cause personally. The independent right to plead and manage one's own cause does not waive the right to the assistance of counsel guaranteed by the Sixth Amendment of the United States Constitution and Article 2, Section 24 of the Montana Constitution, and the correlated unenumerated rights retained by the people guaranteed by the Ninth Amendment to the United States Constitution and Article 2, Section 1 through 35 of the Montana State Constitution. Such a result would sever the concept of counsel from its historical roots, such as lay counsel. Now, what is lay counsel? Lay counsel is someone who's not a lawyer, someone who's not an officer of the court, someone who is not a member of the fascist monopoly called the Bar Association that totally runs the judicial branch of government. Lay counsel. If I was working with somebody that wanted me to assist them in their case and, help them, I don't know, just help them remember things. Maybe they're in the heat of an argument and they don't remember something, and I can point it out to them. You might want to, argue this. Oh, yeah. Hey, Dory, thanks a lot. Okay. Anyway, that's what a lay counsel would be. And lay counsel could literally give you legal advice. But since you're the attorney of record, it's your decision whether you go with that advice or not. Unlike when you're represented by a lawyer, but he makes all the decisions for you. Very few decisions are left up to the defendant with a lawyer. Okay, now going on in the brief, then so I really that's why I want to have this hard copy here because when you look at the stuff, you can take it, you can go on the internet and go do some research yourself, and you'll see that this is something that is I researched this thing for years and years, and I've used it, and it's just amazing when the courts see this. It's amazing when the courts see this, they don't know what to do with it. It's so clear and so concise as to what your right is that they just don't know what to do. I mean, it really freaks them out. I mean, I've one judge I had in Long Beach, I got through arguing the issue, and you know what he said to me? He said, "You're silly." And then he got up and walked out of the courtroom. I was standing there, and the judge just friggin' walked out. I'm looking over at the bailiff, and I'm saying to myself, well, I said out loud to him, I says, "Where'd the judge go?" And he looks at me and says, "I don't know." So I stood there for a while. He never came back out, and I left. So that was his ruling. That was this man who is supposed to rule on the law. I give him everything he needs to make his ruling on. And then he says to me, his ruling is, "You're silly." It's amazing. It's been over the years that I spent in court. Over the years, I tell you what, I have had the experience of my lifetime. It's been one of the craziest roller coaster rides I've ever been on. I mean, every time I go into court, I just wonder if I'm going to find a judge who will obey the law. If the law is unconstitutional, man, they're all over it. Okay, getting back to the brief here. It says the first lawyers were personal friends of the litigant, brought into the court by him so that he might take counsel with them before pleading. Okay, and there's a citation, 1F Bullock, and it's cited right in the case, Frederick versus California, as well as you have a copy of it here. The Massachusetts Body of Liberties, and this is 1641, in Article 26 provided, now listen to this, listen to this. Every man that findeth himself unfit to plead his own cause in any court shall have liberty to employ any man against whom the court doth not accept, to help him, provided he give him no fee or reward for his pains. Frederick versus California. So what the court is saying is that anybody can plead for this guy if he wants them to, if that's what he chooses he wants. They just can't represent him. They cannot go in like a lawyer and charge you up the ass to do it for you. Try that in a court today. Now, this is coming directly out of a benchmark, or what they call benchmark case law. We all know that the judiciary has no authority to create any law, case, or otherwise. Okay, back to the brief here. And that in all courts, all persons of all persuasions, so that means everybody, may freely appear in their own way and according to their own manner, and there personally plead their own cause themselves, or, if unable, by their friends. By their friends. I mean, even when you read Exodus and you're reading about Moses, and Moses is supposed to be the one that is leading the nation of Israel out of Egypt, out of slavery. Even Moses couldn't talk for himself. He had a speech impediment. He couldn't speak. He wasn't Charlton Heston out there, God this and God that, and speaking with this impeccable English. I don't know what the speech impediment was, but maybe it was something like stutter. He couldn't say a word. So his brother, Aaron, His brother Aaron spoke for Moses. So the courts recognize this, that if you're unable to plead yourself, maybe you can't talk, maybe you're like Moses, you got a speech impediment, then you can have a friend come in and say, hey, my buddy over here has got a speech impediment, and he's asked me to go ahead and speak for him. He's told me what I'm to say. I can't speak on his behalf for him, but I will transfer his words through my mouth. And the Bible is full of a lot of stuff like this. You're going to find that the entire appellate system comes right out of the Old Testament. We'll get into that one day. There's so much I got to do. It's hard to get to it all. Okay, moving on with this brief here, and let me switch the camera over there. If a person chooses to have someone other than a licensed lawyer assist him, it's well within his right to self-representation to do so. The Feretta Court also relied on a well-settled doctrine in Powell versus Alabama, 287 U.S. 45, which guarantees a criminal defendant the right to assistance of counsel of the defendant's choice, not counsel of the trial court's choice. The court also relied on the well-settled doctrine of Johnson versus Zerps, 304 U.S. 458, which provides that the right to assistance of counsel cannot be waived unless done so knowingly and intelligently. I'm going to stop there for a moment. See, that's why when I go into court, they tell me if you're going to represent yourself, then you don't have a right to a lawyer. That you represent yourself, so you don't have a right to a lawyer. And I know I have a right to have counsel. I said the assistance of counsel is what I have a right to. And when did I ever say that I wanted to employ and have a lawyer represent me? That would be the death sentence. So no, Your Honor, I don't knowingly and intelligently waive my right. I don't waive it at all. I want counsel, and I want other people to be able to come in here that I need to assist me, as well as somebody that I want to assist me in the law. Since I am the attorney of record, and I'm the one who is making the decisions here, I'll take, under my right to freedom of speech and association, my right to talk on any subject I want to. I'll take counsel what I want, and I will take legal advice from those people if I so desire. It is my decision whether I accept to move forward on the information that they transmit to me. They're not representing me. They can say, hey, I think this, or here's a law here, and I'm going to go ahead. I'll make the final decision because I am the attorney of record. I'm representing myself, and this person is going to assist me in counsel. What if I want two people to assist me as a counsel? What if I want a researcher or an investigator? See, these are things that all the lawyers get to use because they think, because they have monopoly on the judiciary, that they themselves have more rights than the citizen that hires them grants them. How arrogant. How arrogant. These lawyers are arrogant sons of bitches. Accused defendant refuses to waive his right to the assistance. And keep that word in mind continuously, the assistance of counsel. It is also accused defendant's constitutional right to effectively present his own defense. Now we're going to go ahead and read from a court case. An accused must have the means of presenting his best defense. Essential fairness is lacking if the accused cannot put his case effectively in court. The case that's taken from Adams versus United States ex rel. McCann, 317 U.S. 269. Today, more and more citizens, like the accused defendant, or appearing in court in propria persona, representing themselves. In conducting their own defense, they are demanding that the trial. Now, you see that word in there? Demanding. See, when you're talking about a constitutionally protected right, I'm not going to go in the court and say, Judge, is it okay if I have somebody come up here and assist me when I help me? No, you have to have a lawyer, a licensed lawyer. Fuck you. Fuck you. When I come into the courtroom and I have a constitutionally protected, inalienable right, one that you cannot take away from me without due process of law, I'm not going to come in there and get before you and get on my knees and beg you to allow me to have what I have a constitutionally protected right to have. I'm going to come in and make an outright demand. I am going to be the belligerent claimant in person. I am taking that right. And if the court denies me that right, I'm not moving forward. I won't go an inch forward because I can't move forward unless I have a right to assistance of counsel of choice. And I've told that judges over and over again. You deny me my right to have counsel of choice, we cannot move forward. This is the issue. It's going to go up on appeal. I'll stand there. I will not do anything because you have denied me a constitutionally protected right, a fundamental right. I own that right. The courts don't own it. I own it. And I demand it. Who do these people think they are anyway? They're supposed to be our public servants. Shouldn't even have to argue this issue with anybody. But they're corrupt. They're evil. They do not care about the law. They have become laws unto themselves. Back to the brief. In conducting their own defense, they are demanding that the trial court recognize their right to self-representation. This includes persons, sometimes trusted friends, they have chosen to take counsel with during all of the proceedings, their counsel of choice. The concept of lay counsel is nothing new to the court, nor is it a stranger. Now, quoting again, this quoting from a Supreme Court case. Laymen. Who's a layman? I'm a layman. I'm not a lawyer. I'm not a member of the fascist monopoly that's overrunning the court system. I'm a layman. Okay? You're probably a layman. Laymen should be allowed to act as next friend to any person in the preparation of any paper or document or claim, so long as he does not hold himself out as practicing law or as being a member of the bar. The case, Johnson versus Avery, 393 U.S., 483. The position of most the position of most trial court judges is that the court, can choose for the defendant who can or cannot assist him in his defense, or at least force an unwanted lawyer upon him if he chooses to have counsel. This discriminatory action renders a citizen's right to self-representation null and void. His defense is no longer his. It is that commanded by the court. So if you hear you have a right to represent yourself, you have a right to conduct your own defense, and to do that in your own way, in your own manner. And like I said, the only provision there is that you don't violate the rules of the court or you disrupt the decorum of the court. It's not saying that you have a right to go in there and be a butthead. So when the court tells you that you can't have what you need to prepare your defense, to conduct your trial, or to help you work with your writing documents, doing legal research and stuff, then you don't have it. This isn't your defense. You're not doing this in your own way, in your own manner. What it is the court saying, I'm going to conduct your defense, and then I'm going to make sure that I give you no tools at all, none, to be able to operate effectively in court. I'm going to strip you of all that. But I'm going to allow the members of the fascist monopoly corporation, the Bar Association, I'm going to let them bring anybody they want in here. I don't care who it is. Come on in. If you need them to help you, go ahead and do it. But you, the defendant, I'm going to strip you of all your rights. I'm going to tell you how you're going to conduct your trial. When you take a look at it from this standpoint, you can start to see how criminal these courts are. I mean, if anybody should be put on trial for treason, it should be these judges who come out of this fascist corporate bar monopoly, closed shop monopoly. Man, it's just for them only. A criminal defendant, back to the brief, a criminal defendant has a guaranteed right to assistance of counsel of choice, not the trial court's choice. And that can be found in Powell versus Alabama, and that was cited earlier. That's what the word supra means that was cited before. Any waiver of a criminal defendant's right to assistance of counsel of choice must be made knowingly and intelligently. Remember, we talked about that. We talked about before. Now, when a judge tells me that I can't have assistance of counsel of choice except a licensed lawyer, he's taken away my right to make the decision whether I want to knowingly or intelligently waive that. A lawyer is not what they're talking about in the Sixth Amendment. They're talking about counsel, not lawyer, not barrister, not solicitor. Like I said, all lawyers are counselors, but not all counselors are lawyers. Quoting again, this is from another court case. This right to be heard through his own counsel is unqualified. Well, what does the word unqualified mean? If you say that a person has to use a license, if he wants assistance of counsel, he has to use a licensed lawyer, aren't you qualifying that? Aren't you qualifying what counsel is? Now, the courts in Chandler versus Freetag, 348 U.S., they said that the counsel is unqualified. And we know why, because there's such things as lay counsel, right? There are people who assist people who are not members of the closed shop fascist monopoly. Courts understand that. At least they used to understand it. Now they're so goddamn corrupt, you will not go into any court in any state, any federal court in the United States and find anything remotely related to justice. And if you think so, I've got some swampland in Florida I'll sell you cheap. When a citizen is hailed into court, his right to freedom of speech, association, his right to peacefully assemble, his right to freedom of religion, his right to freedom of speech are not suspended when he crosses short swinging doors upon entering the courtroom. First Amendment, United States Constitution, and Article 2, Section 1 and 35, Montana State Constitution. A state could not, by invoking the power to regulate the professional conduct of attorneys, infringe in any way the right of individuals and the public to be fairly represented in lawsuits authorized by Congress to effectuate a basic public interest. Laymen cannot be expected to know how to protect their rights when dealing with practice and carefully counseled adversaries. and for them to associate with each other, to help one another, and to preserve and enforce rights guaranteed to them under federal laws cannot be condemned as a threat to legal ethics. And that comes from a case called Brotherhood of Railroad Trainmen versus Virginia XL Virginia State Bar 377 US 1. And what's interesting about that is that here we have these people that are getting together and they're working together. They're just average Joes like you and I. They're doing the research and they're getting together and they're putting things together. And then basically what the legal profession is trying to do, and let me back up here a little bit, is they're trying to say what we're going to hinder you people. We're not going to allow you to come in here and work together in these courts. We're going to put all these rules on you that completely violate your constitutionally protected rights. We're going to prohibit you from freely associating with anybody. You can't assemble with anybody. You can't talk to anybody. You can't talk, especially you can't talk about the subject of law because we, the lawyers, we own the law. And then when we become judges, we'll make sure that we own the law. So every constitutionally protected you right have under the First Amendment is completely erased because of these goddamn members of the bar. It's the most crazy thing I ever heard of. When you walk into a courtroom, you have absolutely no constitutionally protected rights. The goddamn courts will not recognize anything. And this is done to discourage you. And if you don't know your rights, you stand there with your finger you know where, and you don't know what to say. And when you go into a court, we're talking about an adversary proceeding here. It's war. And you better have the intestinal fortitude and a couple of cojones to stand up against these people. And especially when you go up against these judges, because they have a lot of power. They can throw you in jail. The one thing I learned is that when you're dealing with a judge, and they're all corrupt, every goddamn one of them, if you want to keep from being held in contempt, what I normally do is if I got anything to say to the judge, I present it in a form of a question. Telling the judge to go screw himself is not going to help you any. You're going to end up being put in jail for contempt of court, and we'll talk about contempt of court later. You're going to get put in jail for contempt of court, but you can't be put in jail for asking a question. Your Honor, are you telling me that when I enter the courtroom that I have no right to freedom of speech, assembly, and association? Is that what I'm understanding here, Your Honor? Just asking. Now, today trial courts, back to the brief, today trial courts insist that if an accused wants to plead and manage his own cause, he will have to proceed alone without any help or assistance whatsoever at the counsel table. It's quite common for attorneys to utilize the help of assistants during court proceedings and conduct that business with them right at the counsel table. The accused has observed such activity and diversity of the nature of assistance, which includes assistance of co-counsel, assistance of a researcher, assistance of an investigator, assistance of a paralegal, assistance of an expert witness, all sitting at the counsel table and all sharing their needed advice, talking with the lawyer conducting the case. And often these assistants, well, they're not even members of the bar. The court is a very traumatic place to go. I think most people would rather do anything in the world than to walk into a courtroom and have to deal with what's there. It's all designed to intimidate you. It's right from the bench with the judge sitting up higher than the congregation. the black robe. He comes out. I mean, it's some kind of weird religious ceremony. You know, everybody stands up and, oh, we honor you, oh, high priest of the bench. When the person up there should be walking in and telling everybody sit down, I'm the one that is honored to be able to serve this community. I'm the one that's honored that you've entrusted me with the equal application of the law. I'm the one that honors this position, and I honor this community. It's not your honor as though he's the one that you honor. It should be his honor to be standing before the people of the community and giving justice, not playing some corporate fascist lawyer monopoly game. Every judge, except the ones, at the where the courts have no record, like justice courts, police courts, that sort of thing. Anybody can be that judge, but those courts are you can immediately, after you go to them, you do not have to accept their ruling. You can go have a trial de novo in a real court, the district court, if you choose to. If not, you can go ahead and acquiesce to whatever ruling that the justice court has. So this is where we're at. We are at a point in time where the general public hasn't a clue how this country works, the system works. They don't even know how the legal system works. They don't know how the legislative branch works, how laws are made. They don't have a clue. When it comes to the executive branch, most people think the president is a goddamn king. They bow down and kiss his ass like he's a dictator. It makes me sick the way these parties fall in love with the people that they're putting up for election. Their candidate. Couldn't think of the word. It's sickening. You have the Democrats who just openly and notoriously say, we hate the Republic, we hate the Constitution, and we're going to openly destroy it. And we're going to do it through our democratic process. They hate the Constitution. They hate anything that is decent, anything that is just. All the Democrats are the open side of the Communist Party. It stretches right into the Republicans as well. There's no left and right. It's just one big communist left, and it's in both parties. And I call them the Demo-Republic Nazis. You've heard me say that before. Totally corrupt. I mean, I get on Facebook and I listen to people talk. I mean, we're talking about people who are so ignorant. I mean, to tell you, if this government told them, to stick their head up their rectum, roll down the street like a ball, they'd all get up and do it. Anyway, let's get back to the brief here real quick. We're coming to the conclusion now. In a conclusion and brief, it basically sums up everything that we just talked about as briefly as possible. A criminal defendant's unqualified right to assistance of counsel of his choice goes hand in hand with his right to plead and manage his own cause personally, utilizing the assistance of those persons he would depend upon for his defense. Accused defendant's right to freely associate, assemble, or speak with the person he depends upon in assisting him with his defense is not suspended by any law or statute in any court in the land, providing that those persons assisting him do not hold themselves out to be attorneys or taking fees or other consideration in compensation or remuneration for such services. Furthermore, the accused defendant cannot be forced to act contrary to his sincerely held religious beliefs when those beliefs are already in harmony with the decisions of the United States Supreme Court and Public Law 97-280, 97th Congress. To do so would compel accused defendant to waive his sincerely held religious beliefs in order to obtain counsel. Now, I'm going to stop there real quick. And, this is really important. I'm dead serious. My sincerely held religious beliefs do not allow me to even associate with these people. The only time I associate with a lawyer is when I have to. To me, these people are the absolute epitome of the scum of the earth. They're everything that they've always been. And if you notice the word lawyer and liar, very close. You can go hire a liar. Doesn't sound much different than hiring a lawyer now, does it? I don't know how many times it's funny because it's so difficult to put out the information like this because it's not going to be information that's popular to most people. I mean, what do we normally see on the internet? What gets a million hits? A horse farting and scaring himself. I mean, is that where we're at? I mean, the whole country's falling apart. I listen to people, they all think they know what's wrong. Back and forth, Democrat, Republican. I mean, they're just mindless automatons. I mean, American people are really dumbed down. They are really dumbed down. They are ignorant. I'm beginning to think that we're dealing with stupidity here. I'm certain that the left is predestined to stupidity. Because when I listen to these people talk, it's unbelievable. And then they get mad at you because you want to uphold and defend the Constitution. You want to live in a country where there's real justice, not fairness. Justice is not necessarily fair. Continuing on, accused defendant cannot be forced to waive one right in order to obtain another. And that's a good thing to talk about real quick here. What the court is trying to do is say, yeah, well, if you want to go ahead and have your counsel, then you have to waive your right to self-representation and get a licensed lawyer. Or if you want to come into court and you don't want to use a lawyer and you want to use your next friend, and it's based upon your sincerely held religious beliefs, then you have to give up those religious beliefs. You have to give them up in order to move forward. And I'm telling you right now, your rights are inalienable. Like I said, you can't take them; they can't be taken away without due process of law. They just can't be done. So the court can't come along and tell you that you have to waive a right in order to obtain another or retain another. That's bullshit. I get them all, baby. They're all mine. And some dumbass judge who went to some corporate fascist law school where they taught him a bunch of bullshit and made it very clear that, once you're in the club, baby, we get you up on those judges thing there, and you can be a mini tyrant. You can be king. You can do whatever you fucking want. And even if somebody does come after you, we'll give you immunity. And I mean, we'll cover your ass everywhere you go. Reading on. Such rights are among the enumerated rights retained by the people guaranteed by virtue of the 9th Amendment of the United States Constitution, Article 2, Section 1, through 35 of the Montana State Constitution, as well as the 1st, 5th, 6th, and 14th Amendments of the Federal Constitution and the co-related rights under the Montana State Constitution. Since the power of an attorney comes directly from the accused, an attorney cannot possess more rights than the accused himself. This twisted form of logic runs counter to the fundamental rights of justice and fairness. And that's something I mentioned a little bit earlier. How can an attorney, someone that you hire, now remember, you're hiring him, and when you hire him, he's going to act in your stead. He's going to do everything for you. And then he brings in all of his helpers and his paralegals, and he brings everybody in, and he has this big setup. He's got all the computers sitting on the table, and you're over there, and you can't have anybody assist you. How in the world did the attorney get more rights than the person who granted him the privilege of representing them? Do you see how ridiculous that is? Somehow, when you become an attorney, you have more rights than a citizen. Does that make sense? Doesn't make sense to me. Finally, wherefore the accused prays that this court recognize his right to self-representation and counsel of choice. Now, you can put pray in there or you can put demand. It depends on what you want to do. It's up to you. It doesn't really matter because the courts are going to, violate your rights anyway. And anyway, you can see this particular brief was written in 1999. And that's basically the how the argument is presented in court. Now, I've put this here. I know that a lot of people here, you'll take this information and you put it in the back of your head. But there are some people out there that I know that are going to, going to go to court someday. And if they've taken the time to, learn the rules of the court, to learn how to do their legal research, how to write their briefs, how to set forth an argument, do oral argument, present your case in court, and then not be intimidated, understand how it works, and how to go up against these people. And like we said, I believe it was in the last counsel, your right to counsel of choice and right to self-representation. We mentioned a whole lot of things that are really important as far as understanding exactly what the Sixth Amendment means. And I think now that you have enough information here that later on when we add stuff to it, because we're going to get into your right to trial by jury and your right to, your right to have, the voir dire of the jury and how to conduct your own trial and how to make and meet objections and, how to move forward. And believe me, it's only difficult if you don't understand how it works and have done the proper legal research to be able to understand what's going to be able to come in under the rules of court and what's not going to be able to come in, and that sort of thing. And I really think that this is a subject that is so important, because I've been in the courtroom so many times, and it gets to the point, it's I walk in there and I look up at the judge, and I'm thinking to myself, I know exactly how this man thinks. I know exactly how the bar thinks. And I tell you, when I get into with them, they can't argue with this. They just sit there and say, well, the state law doesn't allow me to do that. You have to have a licensed attorney represent you. No, Your Honor. When did I ever say that I wanted anybody to represent me? I said I wanted to have someone to assist me. Do you see the word here? Assistance? Where does it say representation here? Why are you keep turning assistance into representation? They're two different things. Well, you can't have somebody else represent you. It's like, I'm telling you, it's like talking to a post. Well, anyway, I'm going to wrap this up, and I'm going to thank you, for joining me, because I really like doing this stuff. I like it better than getting out here and talking about all this bull crap that's going on in the political world and the Democrats and the Republicans and all the crap they're doing and listening to all the fake news on TV and all the internet sites that you're putting their own twist on the fake news. It just drives me crazy. Anyway, as I say when I end most of these things, if you're politically correct, then you're legally wrong. And if you're not part of the solution, then you are the problem. I'm the Ghetto Man, and thank you so much for watching. I'm a child of the universe, free to be who I am. The laws of nature guide me and show me how to be my own man. My life belongs to me, this you'll have to understand.